Good afternoon, everyone, and welcome. So we're going to get things started with our Data Hub session, Privacy 101. We are very excited to have our special guest, Laura.
Thank you, Lori. So I'm Laura Crestohl. I'm a senior advisor at the Office of the Privacy Commissioner of Canada. I'm very happy to be talking to you today. Thank you to everyone at Communitech for inviting me here to talk to you. And I guess we'll get started. So I'm just going to share my slides. Okay, and I'll get started. So what am I going to talk about today? Well, first I'll go over why privacy is important, both for individuals and society, and then particularly for businesses. Then I'll talk a bit about the role of the Privacy Commissioner and my office and what we do. Then I'll look at privacy legislation in Canada. So I'll focus on the federal pieces of privacy legislation, and I'm going to go into detail on PIPEDA, which is the private sector privacy legislation in Canada. And then I'll talk a bit about current issues in privacy. I've decided today that the most pertinent might be related to the COVID-19 pandemic. So I'll talk a bit about what my office has been doing over the past few months and related to that. So let's get started. So why is privacy important? So privacy is considered a core human right. In Canada, it's considered a quasi-constitutional right. So it's not mentioned explicitly in the charter, but there are some protections like the right to life, liberty, and security of the person, and the right to be secure against unreasonable search and seizure. And we also have privacy statutes in Canada. And I'll discuss those more in detail later, but they provide protections for individuals in relation to different levels of government, as well as to private actors. But what do we mean when we talk about privacy? In jurisprudence, the Supreme Court has identified 3 types of privacy interests. So the first is a physical interest, so in your body, and privacy not to be sort of invaded. The next is a sort of spatial or territorial right, so the right to enjoy a private space and to be free from surveillance. So this is typically thought of as your home or car to be your own private space. And then the third is sort of what I think we'll mostly be talking about today, which is an informational interest. So it's really the ability to be able to control your personal information and have a say over who has it and how it's being used. So to give an example, I'll just talk quickly about a case. It was a complaint received by the OPC that we investigated, and then it went to court. And it involved a website called Globe24. So this was a Romanian website, and it began republishing Canadian court and tribunal decisions that had previously only been available on Canadian legal websites. And the difference was on the Canadian legal websites, they wouldn't allow the decisions to be indexed by search engines. So the decisions would not come up in the results when you search someone's name. This new site, though, Globe24, did permit the decisions to be indexed by search engines like Google, so that a decision containing the individual's name would come up. And these decisions could involve very sensitive information, so things about divorce proceedings, immigration matters, health issues, personal bankruptcies. So now anyone that wanted to Google a person's name, their coworkers, students, members of the family, could come across some very sensitive information very easily. In addition, when someone would complain to the website and ask for the information to be taken down, the website asked the individuals for payment to remove the information. So the OPC received about 50 complaints from individuals and did an investigation. And in the end, the court found that the website had contravened the law, PIPEDA, as it was collecting, using, and disclosing personal information for inappropriate purposes and without the consent of the individual. So you can see in this example, what they were doing, they were really taking away the individual's control over how to share their information, because this information was already available, just not being shared in the same way. So privacy is also thought of as a right to be left alone by outside actors, sort of given autonomy, agency, and dignity as a person. It's also seen as being a prerequisite to having a flourishing, free, and democratic society. And this is because privacy is often linked to other rights and fundamental freedoms like free expression, so being able to speak anonymously without having harm to your reputation, whistleblowing, and also freedom of association. And when we look at different types of harms that could be associated with privacy, there's sort of tangible harms like financial harms, fraud, bank accounts could be hacked into, identity theft. But there's also intangible harms that could be a bit more difficult to quantify. So these are things like harms to your reputation, people finding out things about you that you might not want them to, and harm to your dignity. So having information exposed, it could cause damage to your sense of self. And we know that especially in this sort of digital age that we live in, once information is out there, it can be really hard to get it back and to sort of claw back to before there was a privacy breach. So for businesses in particular, why is privacy important? Well, first, it's the law. So there are certain legal obligations that organizations have under the law, and we're going to talk more about them in a few minutes. Also, it creates trust in organizations and can improve an organization's reputation. So today in our digital world where personal information can be collected, shared, and used so easily, we've seen that individuals are becoming increasingly concerned about their privacy, and more they're choosing to do business with organizations that are sensitive to those concerns and can demonstrate they'll handle personal information with the appropriate level of care. So the OPC did a survey, and it showed that nearly 80% of Canadians were reluctant to share personal information given news reports about information being lost, stolen, or made public. Most of the respondents had refused to provide information to an organization at some point. Half said they had chosen not to do business with a company due to its privacy practices, and nearly half said that they felt as though they've lost control over how organizations collect and use their data. In our survey, 81% of Canadians said they would choose to do business with a company because it has good privacy practices. So we like to say that good privacy means good business. It can also save costs in the long run, which can provide a competitive advantage. So consequences of not having proper privacy practices in place can include the increased risk of a privacy breach, increase in customer complaints, negative media attention, and a loss of reputation and trust. So specifically speaking about breaches, they can have a very high cost to them. So a study last year by IBM found that the average cost of a data breach in Canada was about $6.4 million US. The main cost was loss of business, damage to the reputation of the company, people taking their business elsewhere. Other costs included legal, regulatory, and technical activities, as well as a loss of brand equity and employee productivity. And these costs were particularly acute for small and medium-sized businesses. Also, as of November 2018, any breach with a real risk of significant harm has to be reported to our office, the Privacy Commissioner. Organizations also have to notify affected individuals and keep records of all breaches. So if you have any questions or want more information, we have a lot of information about breach reporting on our website that you can look at. But I just wanted to give some stats about the first year of breach reporting and what we have seen. So over the first year, we received 680 breach reports, and it revealed that the number of Canadians affected was over 28 million. Some trends in the breaches we saw were that most involved unauthorized access. So this included employee snooping and social engineering hacks like phishing and impersonation. There was a significant rise in the reports of breaches involving a small number of individuals, so targeted personalized attacks. Other types of breaches that we saw were accidental disclosures. So this includes when documents are sent to the wrong person, for instance, being sent to the wrong email address or postal address, or documents are left behind somewhere accidentally. We also saw breaches involving the loss of a computer or a storage device or paper files. and breaches that involve the theft of documents, computers, that led to a data breach. So what does this all mean? I mean, we understand that sometimes breaches happen despite best efforts, but having a good breach response is important to contain the breach and mitigate against any harms. It's also better to think about privacy while developing and growing your business instead of having to react to it after the fact, as the consequences could be quite substantial. So we like to call this privacy by design. It's kind of the idea of embedding privacy principles in your business, in the design of the business. So now I'll talk a bit about the role of my office, the Privacy Commissioner of Canada. So in Canada, there's a federal privacy commissioner. There's also one in every province and territory. And so the powers and jurisdictions of each differ a bit depending on their enabling legislation. So I'll talk about the federal one, and then when I go into the legislation, I'll point out where provincial legislation might apply. So the OPC is an officer of Parliament, and that means that we're arm's length and independent of the government of the day. Our mandate includes giving advice to Parliament and bringing issues to their attention. So we do this in various ways, but mostly we make appearances before various committees, and we also table an annual report every year. Our last one came out in December 2019 and is on our website. We oversee compliance with 2 acts that I'll go into more detail about, but they're the Privacy Act and PIPEDA. And it's generally, the commissioner is an ombudsman model, so we conduct investigations, we negotiate with government agencies and companies to find solutions, and if we're not satisfied that the complaint has been resolved, we make recommendations. And then we can also, if our recommendations, if we're not satisfied, we can pursue court action if necessary. So you might have seen in the news in February, this is what's happening with Facebook as a result of our investigation that resulted from the Cambridge Analytica scandal. So part of our mandate is also public education. So we promote awareness and understanding of privacy rights and obligations, and we provide support and publish research into different privacy issues on our website. So my department is called Business Advisory. So it's kind of a new department. It was created a couple of years ago as part of a reorganization of the office. And it was created as part of the policy and promotion sector. So we're separate from the compliance sector, which is the part of the office that investigates complaints. And the idea was that this kind of, as I was mentioning before, privacy by design. So instead of investigating complaints after an incident has happened, our department helps businesses implement privacy practices from the beginning to help prevent an incident from happening, hopefully, and ensuring that businesses have good practices in place. So what we do is we offer one-on-one consultations with businesses, during which we give specific advice on either existing privacy policies and practices, or we could help with any new programs or products or initiatives that are being developed. During a consultation, we usually meet with representatives of the business. Now with everyone remotely, we're doing it still by teleconference mostly. But we'll review the product or service. We can review any documentation you might want to provide, like privacy policy, employee training materials, a privacy impact assessment. And at the end, we'll offer a list of specific recommendations to help the company improve their privacy practices. And participation in this process is completely voluntary on the part of the business. Our advice is not binding, but it offers businesses tailored guidance on how to comply with PIPEDA and what best practices they can adopt to ensure they're properly protecting the personal information that's in their control. And the process can also offer businesses a certain measure of certainty and assurance, because our advice and the related facts can be used as relevant evidence if the organization becomes the subject of an investigation later on. So now I'll talk a bit about privacy legislation in Canada, and I'll go in depth on some of the requirements in the federal private sector legislation. So first, we have the Privacy Act. So this covers personal information held by the federal government and federal institutions in the course of providing services. So these services examples are old age security benefits, employment insurance, border security, federal policing and public safety, and tax collection and refunds. The Act also applies to federal government institutions like the CRA, the CBSA, the RCMP, as well as crown corporations like the CBC and Via Rail. And the Privacy Act generally limits the collection, use, and disclosure of personal information by these institutions. It also gives individuals a right to access and request correction of any personal information about them that's being held by the federal government. And it's important to note when the Privacy Act does not apply. So it doesn't apply to political parties, political representatives like members of parliament and the Senate. It doesn't apply to the courts, and it doesn't apply to private sector organizations. And that's because private sector organizations are covered generally by PIPEDA. So it's the Personal Information Protection and Electronic Documents Act. And it sets out the ground rules for how private sector organizations can collect, use, or disclose personal information in the course of commercial activities. So it also applies to employee information collected by federally regulated businesses, such as banks, airlines, broadcasters, and telecommunications. Otherwise, it generally does not apply to employee information. It also generally does not apply to not-for-profit or charity groups because it has to be a commercial activity. And it also doesn't apply to political parties and associations. And as we'll see, PIPEDA is considered a principle-based piece of legislation. So it has a schedule with 10 fair information principles. So I'm going to go into each of them in a bit. And it's also considered a technology neutral piece of legislation, which means that the rules are general and they apply no matter which technology has been used. So there's no specific rules for AI or biometrics, for instance. They're just general rules. So PIPEDA applies across the country unless a province has enacted its own legislation that's been deemed to be substantially similar. So right now that exists in British Columbia, Alberta, and Quebec. And it's also important to note that some provinces, including Ontario, have health sector privacy legislation. So in those cases, for the health sector, they will be governed provincially and not by PIPEDA. However, all businesses that operate in Canada that handle personal information that crosses a border, either provincial or a national border, are subject to PIPEDA, regardless of which province or territory that they're based in. And even where the information was collected in a different country, for example, the US or the UK, companies can still be required to meet its obligations under PIPEDA with respect to their handling of that information within Canada. So PIPEDA requires businesses to protect personal information. But what does that include? So it's defined in the legislation as information about an identifiable individual. So this would obviously include things like an individual's full name, address, phone number, a unique number like an OHIP number or a social insurance number. It also could include a photograph, a voice recording, a video, fingerprint. But it's really more than just a direct identifier. It can be anything that can identify a person either on its own or in combination with other information. So it's really a contextual approach and you have to assess it in each different context. So it's hard to say one piece of information, whether it is or isn't PI, because you have to look at all the information that it's being combined with. So simply taking out a person's name does not mean that it's no longer personal information. So to give some examples, a postal code with nothing else might not be personal information. It has a weak connection to an individual. A postal code can cover many houses. However, in certain circumstances, a postal code can be considered personal information. For instance, if it's combined with other information or if the geographical area that it's covering is so small that maybe there's only one person that lives there. Also, like an address with nothing else could be about a property, but if you add in other pieces of information, like energy consumption, heat emanating from a house, a political sign on the lawn. It starts to reveal more and more information, particularly, or that could be about an identifiable individual. So other examples include things like race, ethnic origin, email addresses, messages, IP addresses in some cases, age, medical records, someone's income, a purchase history, spending habits, banking information, credit card data, tax returns, even words you write and things you post online could be personal information. They could reveal things about you. So now I'll talk specifically about some of the provisions and obligations under PIPEDA that businesses have to comply with. So first I'm going to talk about appropriate purposes. Then I'll go into the 10 fair information principles. Also, this is just an overview because there's a lot of information. So we have a lot more information on our website. If you want more details, we have a lot of resources. But I thought it would be important to just sort of go through them and flag some of the issues. So appropriate purposes is found in subsection 5.3 of PIPEDA, and it's considered a critical gateway that either allows or prohibits organizations to collect, use, and disclose personal information depending on the purpose. And this is the first hurdle that protects individuals from inappropriate data practices, otherwise known as no-go zones, colloquially. So the section says that an organization can only collect, use, or disclose personal information for purposes that a reasonable person would consider appropriate in the circumstances. So determining what is appropriate requires looking at sort of a balancing of interests between the individual and the organization, and looking at what individuals are giving up versus what is being gained. So factors have generally included things like how sensitive is the information that's being collected? Does the organization have does their purpose represent a legitimate need or a bona fide business interest? Does the collection, use, or disclosure, is it effective in meeting the organization's needs? Looking at whether there are less privacy invasive means of achieving the same end, and looking at whether the loss of privacy is proportional to the benefits. So just to give some examples of where the commissioner has found a no-go zone in the past. So one would be the case I was speaking about before, where the website was publishing personal information with the intended purpose of charging individuals for its removal. So this was found to be inappropriate. Another case involved landlords using personal information from tenants to make and publish a bad tenant list. So this was found to be an attempt to act as an unlicensed credit reporting agency, which is an illegal act. So in that case, it was found to be inappropriate. Another case of inappropriate data practices involves profiling that could lead to discrimination based on prohibited grounds, like race, sex, religion, sexual orientation, gender identity, and disability. We've also found that an inappropriate practice would be requiring passwords to social media accounts for the purposes of employee screening. And the last example I have is conducting surveillance on an individual using their own device's audio or video functions. So I'll just also mention that we have guidance on this section in particular on our website, if that is of interest. So now I'll go through the 10 fair information principles. So these are found in Schedule 1 of PIPEDA. So this is really why it's thought of as being principle-based. So the first one is accountability. So this means that the organization is responsible for personal information under its control. So organizations should develop and implement personal information policies and practices and train their staff and appoint someone in the business to be responsible for privacy compliance with all 10 principles. So this is usually a chief privacy officer. So staff should know who this person is. It could also be more than one person, and that customers can easily contact this person if they have questions. The designated individual or individuals should also have the support of senior management and authority to intervene on privacy issues. So to fulfill the responsibilities under this principle, organizations should develop privacy policies and practices. And this process should assess what information they're collecting, what's the sensitivity of the information, why is it being collected, how is it being collected, what it's being used for, where it's being kept, how it's being secured, who has access to it, who it's being shared with, if anyone, and how and when it's being disposed of. Also, an organization should be able to demonstrate that they have policies and practices in place to protect personal information, and that they provide adequate training to their staff, and that they've appointed someone to be responsible for privacy governance. So to give you more context, I'll just discuss our recent investigation into Facebook, in which this principle was an issue. So we received a complaint against Facebook concerning Cambridge Analytica's ability to access Facebook users' data. And so Facebook had disclosed users' personal information to the third-party application, which was later used for targeted political messaging. So the OPC found in this case, one of the issues was that Facebook had not taken responsibility for the privacy protection of its users. And it had sort of renounced its responsibility and effectively shifted it almost exclusively to its users and to the third-party apps. So they claim that the third-party apps were responsible for obtaining meaningful consent for these disclosures, and it was the user's responsibility to make informed decisions, and this was found to be inadequate and thus contravening this principle. So under PIPEDA, an organization is responsible for personal information in its possession or control or custody, and this includes information that's been transferred to a third party for processing. So organizations must use contractual or other means to make sure that there's a comparable level of protection while the information is being processed by the third party. And even with a contract in place, an organization should be able to confirm what happens to the personal information after it's being provided to a third-party service provider. And other means can include things like non-contractual oversight and auditing mechanisms. So going back to the Facebook example, Facebook had relied on contractual terms that it had with the apps to protect against unauthorized access to users' information. However, the OPC found in the investigation that these measures were superficial, reactive, and thus ineffective because they weren't properly monitoring to ensure compliance with the terms that Facebook had laid out. So Facebook did not verify whether the uses and disclosures made by the applications aligned with its own privacy standards or whether the information was being properly safeguarded. So the next principle is identifying purposes. So organizations have to identify and document specific purposes for collecting personal information, either before or at the time of collection. And these purposes, as I discussed, have to be limited to what a reasonable person would consider appropriate in the circumstances. And identifying the purposes should help determine which specific information to collect. And so it helps avoid overly broad collection. So when requesting personal information from a customer, these purposes should be explained to them, either verbally or in writing, and they should be clear and as narrow as possible. So just to give you an example from my own life, once I was going to a store to return something, and they asked for my name and address, and I think phone number, and I asked the cashier why, and she told me it was required by the system. So she wasn't able to provide me with a clear reason. I kind of spoke to someone after who said sometimes this information is required for fraud purposes, which could be a very valid reason, but they should be able to express that purpose to the customer. Also, it's important to note that when information is going to be used for a new purpose, this needs to be identified prior to use, and unless the new purpose is required by law, consent is needed before the information can be used for this purpose. So that brings us to consent, which is a key element of PIPEDA. So under PIPEDA, organizations are required to obtain meaningful consent for the collection, use, and disclosure of personal information. So to make consent meaningful, people should understand what they're consenting to, and it's only considered valid if it's within a reasonable expectation that your customers will understand the nature, purposes, and consequence of the collection, use, or disclosure of their personal information. And this is really at the heart of PIPEDA because it gives people control over their information and what they're agreeing to. And we understand that, I'm sure you've all seen, many privacy policies and terms of use can be very lengthy and full of legal jargon. So as a result of this, in 2018, the OPC released a guidance document on how to obtain meaningful consent, which is on our website, but I'm just going to go through some of the main points found in it now. So the first thing we recommend is that businesses emphasize certain key elements. So this includes things like what personal information is being collected, why you're asking for this information, if the information is being shared with any third parties, and any potential harms that may arise from the collection or sharing of the information. We also suggest taking a layered approach, so allowing individuals to control the level of detail that they get and when. So this can be done through using headings, using hyperlinks to more information, using rollovers and pop-ups. So this just makes a privacy policy more manageable as opposed to reading a really long and lengthy document. So individuals should also be provided with a clear opportunity to say yes or no. And we also suggest that businesses be innovative and creative in getting consent using things like interactive tools, just-in-time notices. So that's getting consents, you know, something popping up right before the information is being collected, used, or shared. And we also think that businesses should consider the customer's perspective in making sure it's user-friendly, the information is being provided in plain language. We also think that consent should be a dynamic and ongoing process, so it shouldn't just rely on one point in time, like someone downloading an app or signing up for a service. Organizations should be able to show the steps that they've taken to ensure their consent processes are user-friendly and understandable, so this is part of being accountable for the consent process. There are also different forms of consent. So there's implied consent and express consent. That should be taken under consideration, what is needed. So when determining what form of consent is appropriate, organizations should look at the sensitivity of the information, the reasonable expectation of the individual whose information is being collected, and the risk of harm. So express consent should be obtained if the information is sensitive, if the collection, use, or disclosure is outside their reasonable expectation, or if there's a meaningful risk of significant harm to the individual. So the next principle is limiting collection. So both the amount and type of information collected should be limited to only that which is necessary to fulfill the purposes that have been identified. And it should only be collected by fair and lawful means. So organizations shouldn't be misleading or deceitful to individuals. Limiting collection also has benefits like lowering the cost of collection, storing the information, retaining it, and disposing it. So the less information you have, the less will be your cost. And also collecting less information reduces the risk of a privacy breach. So for example, the OPC usually cautions businesses against asking for a person's social insurance number because so few organizations are legally required to collect it. So if you don't need it, it shouldn't be collected. The next is limiting use, retention, and disclosure. So unless someone consents otherwise, or unless doing so is required by law, organizations can only use or disclose personal information for the purposes that they've identified. Also, personal information should only be kept as long as it is needed to serve those purposes. And organizations should develop guidelines and procedures regarding the retention and disposal of personal information. This should include minimum and maximum retention periods. Personal information that's been used to make a decision about an individual should be kept long enough to allow that individual access to information and to pursue redress. Personal information that's no longer required to fulfill the identified purpose should be destroyed or erased or made anonymous. And it's important that before disposing of electronic devices to ensure that all personal information is fully removed. So this principle was an issue in an investigation that we did into the dating website Ashley Madison that had been hacked into, and private user information was disclosed by a hacker. So when the OPC investigated, we found that profile information relating to user accounts which had been deactivated and profile information related to user accounts which had not been used for a prolonged period were being kept by the site indefinitely. But because the purpose of the collection had been to provide an online dating service, after a certain period of time following deactivation or following use, it's highly unlikely that the user would return to the website. Therefore, the information was no longer needed for that purpose. So at that point, and absent any other legitimate purpose for retaining the information, the site should have destroyed that information. The next one is accuracy. So organizations have to make sure that personal information is as accurate and complete and up to date as necessary. So this will minimize the possibility of using incorrect information when making a decision about an individual or when disclosing information to third parties. So organizations should establish policies that govern what types of information need to be updated. And one way to determine whether information needs to be updated is to ask whether using or disclosing out-of-date or incomplete information could potentially have an adverse effect on the individual. So one quick example of this is just email verification. When you sign up for a site and it verifies your email, that's ensuring that the information is accurate. So the next one is safeguards. So all personal information must be protected against loss, theft, or any unauthorized access, disclosure, copying, use, or modification. So security safeguards should be appropriate to the level of sensitivity of the information. So the more sensitive the information, the higher the level of protection should be. And it's important to note that PIPEDA does not specify any particular security safeguards that must be used, but organizations must continually ensure that they adequately protect the personal information, especially as technologies evolve and as new security risks emerge. So different methods of protection should include physical measures. So this could include locking filing cabinets that have personal information, restricting access to offices, having alarm systems in place. There should also be organizational measures like security clearances, limiting access on a need-to-know basis to employees, training staff properly, having agreements with staff and clauses involving privacy practices. And the last one is technological tools. So this would include things like having strong passwords, using encryption, firewalls, and security patches. And these practices should be reviewed regularly through audits or testing to ensure that they are up to date and that any known vulnerabilities have been addressed. The next principle is openness. So an organization must make its privacy policies and practices readily available to individuals, and it should be in a form that's generally understandable. So the language of the policies and practices should be clear and not overly complicated. So an example is that the OPC once got a complaint from an individual who was at a car dealership, and they were getting her information, and she asked the staff member why her personal information was being collected and what safeguards were in place to protect it. The employee simply said that was the procedure he had to follow. The complainant then sent an email to the dealership's privacy officer, but she never received a response. So the OPC found that all employees who are collecting personal information should be able to answer questions about why the personal information is being collected and should be able to address any concerns, and that she should have been given information about their privacy policies and practices. The next one is individual access. So generally individuals have a right to see the personal information that businesses hold about them. They also have the right to challenge the accuracy of that information and its completeness and have the information amended as appropriate. So there are some exceptions, but they're very limited and specific. So for information, if the information, or for example, if the information contains references to other individuals' personal information, or if it's covered by solicitor-client privilege. But otherwise, the request has to be responded to within a reasonable amount of time and at a minimal or no cost to the individual. And the requested information should be provided or made available in a form that's generally understandable to the individual. So if there's any acronyms, they should be explained. And if an individual can then demonstrate that the information's either inaccurate or incomplete, the organization has to amend that information. So organizations should develop a procedure for responding promptly to any requests, and they should inform their customers how their information has been used and amending it if it's been found to be deficient. The last principle is challenging compliance. So organizations should let their customers know that what they can do if they have a concern or further questions about how their personal information is being handled. So they should develop simple and accessible complaint procedures and investigate any complaints that they receive. And if a complaint is found to be justified, the organization has to take appropriate measures, including, if necessary, amending its policies and practices. And any complainants should also be informed about any other avenues of recourse that they might have. So this would include the organization's own complaint procedures, along with those related to any industry associations, regulatory bodies, and if they can make complaints to the OPC. So now I'll just discuss some current issues in privacy. So again, I wanted to go over just the work that the OPC has been doing since the pandemic. So right now, the pandemic's raising a lot of interesting questions about privacy issues. So our office has said that during a public health crisis, privacy laws still apply, but they should not be seen as a barrier to appropriate information sharing. So some of the things that we've done, the first was back in March. We released guidance titled Privacy in the COVID-19 Outbreak. So we looked generally at how the Privacy Act and PIPEDA might apply to some situations created by the pandemic, which provisions might apply. For instance, circumstances when organizations may be able to collect, use, or disclose personal information without consent. Then we released a framework to help the Government of Canada assess privacy impactful initiatives that are being undertaken to address the pandemic. So we emphasize things like looking at the necessity and proportionality of the measures being developed. We also released tips for Canadians to consider when using video conferencing services like Zoom. And it includes tips like be careful what you have in the background, what personal information people might be able to see, also using strong passwords, being sure you know what's in the app's privacy policies, making sure you're using the most up-to-date version of the platform because they often fix any vulnerabilities that they find out about. And the last was a joint statement that was issued by the federal, provincial, and territorial privacy commissioners about contact tracing and similar apps, and laying out a framework that they should follow in order to protect privacy. So this looked at things like consent and trust, legal authority, necessity and proportionality, making sure the purpose is limited, that de-identified or aggregate data is used whenever possible, that the initiative is time limited, and that there are proper safeguards, transparency, and accountability in place. So also I just wanted to point out some PIPEDA resources that we have on our website that might be of interest. So first we have our privacy toolkit for businesses. Usually when I go to events, this is very popular. It's kind of an overview of PIPEDA. It gives more information about each of the principles and how to comply. I know that we're also updating it, so I think a new one's going to come out fairly soon. So you can check on our website for that. We also have just some quick tips, privacy tips for businesses. We also, I think, as I mentioned, have specific guidance about inappropriate data practices and obtaining meaningful consent. Our website also has more specific resources and general guidance. We have some PIPEDA interpretation bulletins, so they'll look at how we've interpreted things like what is personal information, what is commercial activity. And then also I should just mention that PIPEDA as a law is 20 years old. So it doesn't really contemplate a lot of new technologies and the amount of personal information that's being collected, used, and shared. And it could be seen as a bit outdated. So the OPC, we released our annual report in December, and it has sort of a call on the government to reform PIPEDA and it has a proposed rights-based approach. So if you're interested in that, you can look for that on our website as well. So that's all I had for you today. Thank you for listening. I'll take any questions, I think, if you have any in the chat. Be happy to answer.
Thanks a lot, Laura. So we have one question. The first question is from Romik. And Romik is asking, can a startup submit their business privacy policy in terms of use document to review?
To us?
Yes.
Yes, so we can, they can request a consultation. So we usually do an initial meeting where we discuss what sort of the business plan is, the product. We get a little more information, and then we can, I usually have to go to my director, and if we choose to enter, we do have, I should mention, we do have terms of engagement that the business has to agree to before we sort of start a formal consultation. But most of the things in there are things that I mentioned, that it's voluntary, it's confidential, and things like that. It's not binding. So that's sort of how the process gets started. People can contact me if you're interested, and then we could talk more about the specifics. But we do generally, we look at sort of the business practice, and then we can give tips and advice on things like privacy policies and other documentation that you might have.
Perfect, thank you. We do have a few more questions. Before we move on to the next question, I just wanted to remind everyone that if you do have questions, you can still post them in the chat here. Now, Laura, the second question comes in from Sandra, and Sandra's asking that the European privacy law, so GDPR, put a very strong accent on the problem of data exported and conserved out of the European Union borders. The Canadian laws on privacy include the regulations of this kinds. Does that include this type of regulation of this kind of problem? Or maybe does Canada have separate agreements with other nations on this subject?
Yeah, so we usually refer to this as trans-border data flows. So it's quite complicated. And the OPC, we do have information about it on our website. So again, as I said, like PIPEDA is quite an old law. The GDPR, so the European law, is much newer. So it has things in there that PIPEDA doesn't really contemplate. So I think that's sort of one of the issues. And I think it's important to make, if it's traveling over a border, it's important to make that clear in the consent practices. So to be clear to customers that, because sometimes if a third party service provider is located in another country and the information is traveling, again, as I mentioned, the company is still responsible for when it's disclosing this information for processing. So I think it's important to make those things clear. And again, I would encourage going to our website and looking up trans-border data flows. We have more information on that, but it is a bit of a live issue.
Perfect, thanks, Laura. We have another great question, and this one is from Wendy. Wendy's asking, in the automotive world, do privacy rules apply as it relates to vehicle safety recalls? Can dealers communicate with customers without consent, for example?
This, I'll actually say I'm not sure the answer to this question. Again, PIPEDA generally applies to information being collected, used, or disclosed for a commercial activity. So you'd have to look at if that's a commercial activity and whether it applies. I've never looked at this example before, so I'm sorry, I can't give a sort of straight answer.
That's all right. She has a follow-up, which might be a bit more general. Does implied consent exist when a customer has transacted with a business? Also, is the implied consent limited to 2 years?
So there is implied consent in certain circumstances, and I think it's an evaluation. So the company has to look at different factors to see if implied consent might be appropriate in the circumstances. So the factors, so express consent is definitely needed when the information is sensitive, when the information, when it's outside the customer's reasonable expectation. So when a company might be collecting information that the customer might not be aware of, or just sort of known in common practices. And the other case is that express consent is needed when there's a real risk of significant harm. So it's kind of a contextual approach that you have to look at what is the circumstance to know whether you need to get express consent. If express consent is not needed, then implied consent might be appropriate.
Okay, perfect. Thank you very much, Laura. So that's it for the questions. And Laura, I wanted to say thank you very much for offering your time and effort to present at this session today and for sharing your insights on privacy law in Canada, the role of the OPC, and current issues. I'd like to thank also our sponsors, Avon, Sengen, and Encore for making this Data Hub session possible and for funding this regional technology development site. And thank you all for coming to another Data Hub session. We'll be sharing the slides with you this evening along with a survey. And I'd like to thank you in advance for taking the 2 minutes for sharing your feedback on today's session. Enjoy the rest of your day. Thank you very much, everyone.
Thank you.